On debate, Senator Dalphond.
Senator Dalphond. Thank you, Madam Speaker.
We are entering the last stage of our study of Bill C-7, alterations to Canada's constitutionally required framework for medically assisted dying. And as we enter in that, I would like to address some of the context relevant to this debate, including the legal requirements and the expectations of Canadians. But first, I would like to pay tribute to the members of the Standing Committee on Legal and Constitutional Affairs, who, since November 2020, held 9 full days of hearing, totaling 56 hours of testimony from 145 witnesses, and who have spent countless more hours to review more than 100 briefs. The committee heard from a wide variety of perspectives, including ministers, provincial and regulatory authorities, advocacy groups, people living with disabilities, academics, legal and medical practitioners and experts, Indigenous representatives, and people with personal experience with MAID. I want also to acknowledge the hard work of my colleagues on the steering committee, our chair, Senator Jaffer, and Senator Batters and Senator Campbell. Unfortunately, Senator Campbell had to take a step back for health reasons in December, and I look forward for his return amongst us in good shape. Through the entire process, we were assisted by devoted staff in our respective offices, by a highly efficient committee clerk, Mark Palmer, and by 2 exceptional analysts from the Library of Parliament, Julian Walker and Michaela Keenan-Pelletier. All of them perform public service beyond the call of duty, especially during a Christmas recess. And I wish to thank them for their invaluable support, availability, and contributions. On process, I would like to also congratulate all Senate leaderships on the agreed-upon framework for our upcoming debate, building on the practices developed last Parliament around the first MAID bill and the cannabis legislation. I'm pleased that this debate will be structured, including in the amendment process, and that our final vote will be scheduled. This approach will afford Canadians greater access to our work. I now turn to Bill C-7. The background of this bill is quite simple. Further to the Quebec Superior Court decision in Truchon of September 2019, the Attorney General of Canada acknowledged that the reasonably foreseeable natural death requirement to access MAID was inconsistent with the Supreme Court's ruling in Carter. Incidentally, that conclusion was reached by the Senate as early as 2016. It is regrettable that since then, access to MAID has been denied to many Canadians with enduring and intolerable suffering.
In committee, Jean-Pierre Ménard said of the Quebec Superior Court's decision that it was very much in line with the Carter decision. She makes it very clear that what the Carter decision said was very clear and does apply to Mr. Truchon and Ms. Gladu. She saw no reason to depart from it or to decide otherwise. In Carter, the intolerable suffering felt by the patients was the criterion for the court's decision, end of quote. Once Bill C-7 is passed and comes into force, the mistakes made by the government and the House of Commons in 2016 will be corrected forever. And this will allow Canadians who are suffering and who meet the eligibility criteria to choose with respect to their autonomy a peaceful death. By correcting this error, Parliament will not only be upholding a right constitutionally protected by the Charter of Rights and Freedoms, the right to decide for oneself on the end of one's life, including at a time that respects one's right to dignity. Indeed, we will also respect the will of Canadians. According to a recent Ipsos Canada poll, no less than 86% of respondents agreed with the Carter decision, with the percentage rising to 89% in Quebec. In addition, in response to a specific question on the primary objective of C7, to remove the reasonably foreseeable death test, 71% of respondents indicated their support. That said, the removal of this criterion cannot hide a differentiated reality. On one hand, that of persons who have reached a point of intolerable suffering and whose death is reasonably foreseeable, and on the other hand, that of persons who are confronted by intolerable and irremediable suffering, but who could still live for many more years. Faced with this undeniable factual situation, the government has chosen to adopt two sets of criteria for eligibility for medical assistance in dying. While some witnesses would have preferred only one set of safeguards and eligibility requirements applicable to all applicants, I am of the view that the reasonableness of the differentiated approach chosen by the government and endorsed by the majority of parties and members of the House of Commons cannot be denied. In the coming days, some will be proposing amendments to the safeguards for each of the situations, some of them because some will feel they don't go far enough and others feel they will be going too far. For my part, I note that the bill strikes a balance between autonomy and the protection of vulnerable persons by adding safeguards for persons whose natural death cannot be reasonably foreseen. There's an obligation on the part of the practitioner to explore with the patient all services available to relieve suffering, including psychological counseling, mental health support services, disability support services, community services, and palliative care.
Minister Lametti explained the purpose of the second track, and I quote, "As part of the development of Bill C7, the Minister of Health and I met with organizations and individuals speaking on behalf of persons with disabilities at roundtable meetings held across the country in January and February 2020. One of those roundtables was focused precisely on disability rights and mostly made up of national and regional disability rights organizations. This legislation reflects concerns raised at these consultations with the inclusion of a two-track system with greater safeguards for those whose death is not reasonably foreseeable." End of quote. That being said, I acknowledge that we, as a society, still need to devote more resources to address the needs of people with disabilities, to provide access to palliative care in remote areas, to do more research on various illnesses and their treatments, as well as to have further research on social determinants of health. For example, we need to better understand the social factors in play when individuals make important decisions about their health and life, including about any kind of serious treatments or interventions. For example, what makes a person choose continuous palliative sedation or MAID? But unless we revert to the old paternalistic views that have long guided medical practice, we have to be firm in protecting the right of patients to be fully informed and to decide independently what is best for them. The whole medical practice rests now on the concept concepts of informed consent and patient autonomy. The Canadian Charter of Rights and Freedoms protect that sphere of autonomy. Deficiencies in research data or gaps in the health programs, services, and structures in place are not a reason to deny or restrict that sphere of autonomy. The very real concerns of insufficient funding, racism, and bias in the healthcare system should not override the constitutional right of those with enduring and intolerable suffering to access MAID if that is what they truly want. Valid concerns about some other, equally important, rights cannot justify the negations of others' rights. In other words, imperfection do not justify continued suffering. Madame Nicole Gladu.
Ms. Nicole Gladu told us that what she wished was to be able to put an end to her life at a time of her choosing, and I quote, efficiently and without suffering, with my wonderful friends, a glass of pink champagne in one hand and a sofa in the other, admiring for one last time from my living room the sun setting over the river, end of quote. Let's not deny Madame Gladu and others in similar circumstances the possibility of putting an end to their suffering as peacefully as possible, accompanied by their loved ones. Let's not deny their loved ones the opportunity to participate fully in the end of life of their loved ones and to say goodbye, as the loved ones of Marilyn Gretzky were able to do.
Bill C-7 has struck a reasonable balance by removing the reasonably foreseeable death criterion and strengthening the applicable safeguards for the second track. This approach acknowledges diverse perspectives in the disability community, and at no time does it encourage people with disabilities to choose MAID or endorse any such ideas. It is important to remember that access to MAID is based on informed consent by the requester and by nobody else. That said, I agree with many senators that Bill C-7 could be improved by us. As you know, I have expressed serious concerns about the proposed exclusions of individuals with mental illness as a sole underlying condition. One of these concerns is about the lack of a definition of what is considered mental illness for the purpose of access to MAID. Tomorrow, I will have the honor to present an amendment to the bill to clarify that the exclusion regarding mental illness should not include neurocognitive disorders such as Alzheimer's disease, Parkinson's disease, Huntington disease, and dementia. Otherwise, Bill C-7 will actually restrict access to MAID compared to the current regime, a result that will be a step backward, totally unacceptable and unconstitutional. Another concern I have is about the exclusion of mental illness altogether. As pointed out by many psychiatrists and other medical practitioners, this amounts to a further stigmatization of those suffering from mental illness. Furthermore, as stated by many legal experts, this broad class exclusion is contrary to the individualized assessment approach advanced in Carter, Truchon, and reiterated more recently by the Supreme Court of Canada in Attorney General of Ontario versus G. However, I am mindful that many witnesses said that the elaboration of the required guidelines and standards for patients with mental disorders will take some time. In this context, the adoption of a sunset clause will be, in my opinion, a reasonable way to address the interim period required for the provinces and the medical profession to establish the appropriate guidelines and standards for responsible and uniform access to MAID, where the sole cause of unbearable suffering is mental illness. In conclusion, I look forward to the debate in the coming days as we work to achieve the best public policy for Canadians through our contribution of sober second thought. Merci, miigwech. Thank you.